The discovery process at its heart is intended so that they're not surprised of your case and your evidence against their case. That's what it's intended to do. The court reporter doesn't record like length of time between answers. The court reporter doesn't record, attitude, good ones or bad ones. You know what I mean? This is for the sole purpose of using at trial. You kind of start off with basic questions and you build a rapport. So the really best examinations for discovery they kind of look like a conversation, and it's just you and I talking, and what's the big deal? Those are the best ones. It's dangerous to sometimes be like kind of a smart aleck kind of a thing, like not like whatever, sure, like sure answers like yes, you know what I mean? Not like whatever, that's a stupid question, that's how it answers. So you want to be very clear on it. The other thing that's very good is get the person very angry or upset. Then they start saying things. You're there for a full day, so it's going to be a long day. It's probably one of the most uncomfortable, worst parts of litigation. There's no judge to protect you. It's just me. And I can only protect you by objecting. If I object, don't answer the question, even if you think it's the best answer out there, because it's on the record. So I've objected, you've answered, it's answered. Objections can be many different things. The biggest one is relevance. So that comes from pleadings. If I object, he says it's relevant because of this, why he pulls out the pleadings or whatever the case is, and I say go ahead, then go ahead. If I don't object, you have to answer the question, or you should answer the question. You want to hear the question, make sure you understand the question. You don't want to be too difficult, but you certainly don't want to be too agreeable.
Right.
Okay? So take your time. Okay? So don't have to rush it. There's no bonus points for speed. Like I said, in the questions, you could sit back and take 5 seconds to think about it. And it doesn't show that unless they say out loud, If it's getting a little bit like I said, a really good strategy is rapid fire at someone. That's where you want to have your water, have a sip of your water, take a break, think about it. If you feel yourself getting like annoyed, do something to fix that, because that's where people really make mistakes. Don't generally ask a question. It's not for you to ask them questions. If you're looking at a document, or if it refers to a document, look at it. So even if you looked at it today and we do this, take your time, read through it. Don't be ridiculous about it, but if he puts to you a 10-page contract, the contract or one of the main contracts, look at it. And he shows you an email. Okay, so first of all, take some time to look at it.
Right.
Look at who it's from, when it is, really look at it. Read it. Don't assume. What people do is they're assume oh yeah, that's where I said something negative, and then they say, yeah, okay, I guess I did. Look at it and say, okay, well, look, this is, one way to read it is it's negative. Another way to read it's he's a scumbag, aggressive lawyer. Some people think that's positive. And I didn't mean it in a negative way. I don't know if that's true or not, but I'm giving you an example of, don't just give in on anything. Read it, and then / be reasonable. If you say something and you then realize, oh, that wasn't accurate, or it didn't really make sense, or you can change your answer. Change that. You can say, look, you know what? When I said that, it wasn't 100% correct. I want to put some context to it, or something to that effect. Don't let him put words in your mouth.
Right.
Or put in assumptions and questions. So it's important that you stay focused. You don't, you don't kind of get caught up. You don't get twisted. You don't get angry. You don't get emotional. It's important. Not so much in now, but it's important just so you get good practice, Now, another really good thing that works in examinations of discovery is that they ask you a question about something that was happening, say, at the time, the material times. And you know so much more about that now. Put yourself in the mindset of when what was happening.
Right.
Not what you know now.
Right.
Okay? So, the truth is always better for the most part.
Yeah.
You don't have to worry about remembering it later. It is what it is. It's in documents like email. So if you said something that's clearly in an email that says otherwise, that's a problem. So that's why you need to read your emails and correspondence. If you say something that's clearly in an affidavit that says otherwise, that's very problematic. And that tests your credibility.